Hey folks, I'm attorney Roger P. Foley. I'm driving home from the office today and I'm thinking about client expectations. And the reason it came up is I had a couple people call me today and they wanted me to take over quite serious cases, like a drug trafficking case where there's a confidential informant and another case that was pretty lengthy and detailed. And the main reason that they wanted me to take over, one was because they hadn't found me sooner. One person had a family member that hired an attorney and they don't like that attorney. That attorney doesn't communicate with them. The other person is thinking that, hey, the attorney's not doing enough. It was actually thinking that the attorney was helping the state. And I said, nah, that would be extremely hard for me to believe. That would be like 1 in a billion type of odds. And I asked the individual, I said, how much did you pay them? And they told me they paid the person like $7,500. I go, for a drug trafficking case? And they said, yeah. I said, the first thing you should know, and what another attorney knows, right? It's not like we have inside information. If someone's charging $7,500 on a drug trafficking case, they're pleading you guilty. You think that they're looking for the affidavit for search warrant and that they're filing technical motions to invalidate the search warrant, or different types of motions to suppress based on facts of the case? Are they going to bat? Like, are they giving it everything? Right? You can go for a jog, right? And I don't know, back when I used to run, I could go for a jog and run a 7.5 minute mile. And it was a good pace, right? And like, I could have run that pace now, but like when I was at my peak level, like I could run a 6-minute mile. So if they're running a 7.5 minute mile, they're just like stretching your legs. Like, it's a good pace, but it's not enough to win the race. If someone's paying $7,500 for a drug trafficking case, they're not paying. They're not doing it. And is it right? No, it's absolutely flipping wrong, because it doesn't matter if an attorney takes $100 or $1,000 or $100,000, right? We as attorneys are supposed to give it our best. And back in 2013, I changed my retainer agreement because I was going balls to the wall on every single thing. Depots, technical arguments, right? And it's only so much time. So I started realizing some clients, they're okay with probation because for whatever their reasons are, maybe they're admitting that they're guilty, maybe they have a confession, whatever it may be, but they're super happy to get a deal of probation on a 3rd degree, 2nd degree, or 1st degree felony. They're like, hey, you get me probation, brother, we're good. And I don't have to file all those technical arguments. So I started saying, you know what? I'm not going to charge people to fight the big battle unless they're fighting the big battle, right? And when I say big battle, I mean, I'm taking depots, I'm ordering CAD reports, I'm going out to the scene, I'm hiring an investigator, I'm hiring experts, I'm interviewing experts, I'm going through all of these different things. So how do I manage a client's expectation? I tell them, for this, you get this. For this amount, you get this. You choose the option, right? And I usually tell my clients, go the cheaper way first, because like, if it doesn't look like I could really win, because you can't win every case, you're as good as your facts, then I say, let me look through the discovery and see if there's anything that jumps out. And if there's something that jumps out where I already know the answer, like, hey, I have a legitimate motion to suppress, right, to get rid of the evidence and get rid of the case, well, then I'm going to do it, right? Like, then we can talk and you pay extra and I go file that. But I look at it. I look at it because I have an ethical responsibility to look and give my client options. Every defense attorney out there, regardless of what the public thinks, their job is to give you options. Option A, is it possible to get a diversion program? If it is, like, that's a great option. Option 2, are you going to plea the case? Option 3, are there technical motions and arguments that can be filed? Or 4, are you going to trial? And really what the case comes down to all the time, I always say it's either plea or trial, because even diversion is some sort of plea, right? So you're either pleading the case or you're fighting it all the way. Sometimes I wish, I told the client that today, I go, sometimes I wish just people just hire me just to fight. I don't have to kiss up. I don't have to pucker up. Hey, could you do this? Hey, I don't think there's anything more difficult than a grown man begging another grown man or a grown woman to do something that really doesn't even have to do with them, right? It's your shit. But I'm paid to do that. So if I'm paid to pucker up, then I do it. But I don't want to do it. I'd rather just set every case and file a motion. But you know what the reality is, folks? Every case doesn't have a technical argument. Every case doesn't have a real legitimate shot of winning. And because of that, my job is to protect you, like you. It's not what Roger P. Foley wants, right? It's not what my staff wants. It's what's best for the client. And what's best for the client is educating the client, giving them options, telling them like, look, I got a pretty good shot on this motion, or, hey, listen, I know you're asking me to file this motion, but the odds of it getting it granted are so slim, like you're almost throwing money away, right? I can't even think of an analogy, right? I'd like to lose 40 pounds. And if someone came over and said, hey man, I got a magic pill and you'll drop 40 pounds tomorrow, I'd be like, yeah, how much, right? No, I wouldn't ask. I would go, no, it's a waste of time. I'm not gonna lose 40 pounds in a day. It's not gonna happen. As an attorney, I know what's legitimate and what's not. If I have a 1% chance, I'm gonna file the motion. But I also think that you as a client deserve to know that it's only got a 1% shot and you're paying for that. So it's all about options, folks. That's how I manage client expectations. I got option A, I got option B. Which would you like to go with? These are what I think your odds are. Whichever way you go, I'm gonna give it my all. Because just I get so many calls where they're switching because the attorney doesn't tell them anything. The attorney doesn't tell them that, hey, if you got a dealing in narcotics, you have a trafficking charge, you have possession of a firearm by a convicted felon. They don't know. They don't really know how to read the discovery, and that's what the attorney's job is to do, is go like, look, man, this is really bad, and here's why it's bad. Here's something that's really good for you, and here's why it's really good for you. Explain so you the client can make the determination. We going left or we going right? And you know what? A lot of times the client goes, what would you do? And there's sometimes I can say, well, I would do this if it doesn't hurt them. But if it has just a shot at hurting them or making their case worse, I go, look, you got to make that decision, because if you do this and we're not successful, this is how it can harm you. And you got to know that. And I just think that's what is missing in a lot of offices. And I only say that not because of my experience with a lot of offices, because of so many cases that I take over from other attorneys. They have no clue, and they're 6 months, a year into a case, and the judge is already, calling for a trial docket. That's not right. You got to let your client know what's up, and your client's got to make decisions. So it also goes for the client. You can't go, I don't know. And I've had those clients too, and they're nightmares. You have to make a decision, and you have to go with it. So anyway, I'm attorney Roger Foley, managing client expectations. I know I'm long-winded. God bless you for listening to the whole thing. See ya.